Hello friends, I Shubham Jain from the team CLJ, a drive for sustainable corporate world, and you all are watching this channel for simple analysis of the critical information under corporate and commercial laws. Friends, today we feel immense pleasure to welcome Pratika Shankar, who is a managing associate at Talwar Thakore Associates, Mumbai. He is a corporate lawyer and specialization in inbound and outbound strategic M&A, private equity and structured finance. Pratik has 7 years of experience in a wide range of domestic and multinational corporations, private equity funds, and banking and financial institutions based out of different jurisdictions such as USA, UK, France, Singapore, and Mauritius, etc. With this brief introduction, we welcome Pratik for today's session. Thank you.
Greetings to the Corporate Law Journal team and hello everyone. It is heartening to see a group of young Indian law graduates being driven by the need for a sustainable corporate world, who have come up with an online law journal that deals with contemporary issues in the corporate and commercial law space. Conducting video sessions as this one is a particularly innovative idea because it deals with the legal developments as well as their practical implications. I feel it is going to be immensely beneficial for corporate law professionals such as myself, as well as for law students and professionals and students from other disciplines such as company secretaries and chartered accountants. I congratulate the Corporate Law Journal team for all the hard work that they have put in so far, with the aim and vision of imparting corporate law literacy in a simple and lucid manner, and wish them great success in the future.
As the whole world is fighting against this coronavirus, which is not just resulted into loss of lives but also severely impacted the business community, commerce and the global economy due to the lockdown and the restricted movement, it also led to huge scope of uncertainty over the commercial interactions and the business arrangements. Keeping in mind the present situation, Team CLJ selected today's theme for discussion is force majeure and the frustration of the contract in the context of the COVID-19. As we all know, these two doctrines are not new in the Indian context. Also, we have a plethora of jurisprudence over these two doctrines. But Mr. Pratik is going to discuss the practical implications over these two doctrines in the present context, which have utility for the lawyers or even the person who are not from the law background. So please note that all the views expressed by our guests are personal in nature, which should not be construed as opinion or viewpoint of any firm. I hope you all will like this video. Please do not forget to subscribe this channel for our upcoming brainstorming videos with eminent personalities. Thank you so much.
As we all know, the COVID-19 pandemic has completely changed the way we look at ourselves, the way we look at others, and the way we look at the world in general. There's an increased sense of insecurity in our personal and social interactions from a public health and safety perspective. There's a great deal of uncertainty in our commercial interactions and business arrangements. In addition, the series of lockdowns imposed by the government in order to curb the spread of the pandemic has already had far-reaching consequences on various business establishments and parties to commercial contracts. Two legal terms that have assumed the greatest significance in the present context and are being heard all the time are A, the doctrine of force majeure, and B, frustration of contracts. There's a great volume of literature available on these concepts. There's a plethora of judicial interpretation which explains the meaning, scope, and application of these principles to commercial arrangements. However, the focal point of today's discussion is not to understand the theory, but rather to demystify, or as we call them, to dumb them down to a level where, irrespective of whether you're a lawyer or not, you should be able to understand these concepts pretty well. So let's begin with the concept of force majeure. The term force majeure means an event or an effect that can neither be anticipated nor controlled. Interestingly, the Indian Contract Act does not contain a definition for the term force majeure and does not expressly use this term in any of its provisions. However, the essence of the concept of force majeure is captured in the Contract Act by a class of contracts which are known as contingent contracts. As the name suggests, contingent contracts are contingent or conditional upon the occurrence of an event or a series of events. Now, if the occurrence of this event or a series of events becomes impossible or is rendered impossible because of extraneous circumstances beyond the control of either of the parties, then the contract becomes void. Now, that's the theoretical part. What does it mean in practice? Now, let's take an example. If A and B enter into a contract pursuant to which B is required to manufacture a particular product and deliver to A within a set period of time. However, the contract also contains a clause which says that if the performance of the contract and delivery of the goods by B to A is hindered by extraneous circumstances which are beyond the reasonable control of either of the parties, or especially B, given that B has the obligation to perform the contract by delivering the goods first, then the parties will in good faith renegotiate the terms of the contract and, if possible, an extension of the timelines. Now, this is a classic case of how contingent or conditional contracts work, and this is also an example of how a force majeure clause is drafted into contracts. The examples of force majeure clauses include clauses which contain conditionalities in relation to acts of God, conditionalities, for example, in relation to wars, to acts of terrorism, to strikes, to lockouts, to epidemics, pandemics, etc. Now, it is interesting to understand that a key difference between the concept of a force majeure and frustration of contracts is that either of the parties to a contract can only claim force majeure if it has been already anticipated and provided for in the contract. So if the parties have considered the risk that the performance of the contract may be hindered by an act of God, for example, but having considered that they have not included a force majeure clause into the contract, then parties cannot later on claim a force majeure and on that basis avoid performance of the contract or delay their existing timelines in the contract. That brings us to the second concept, which is the concept of frustration of contracts. Frustration of contracts is provided for in Section 56 of the Indian Contract Act. It means that if the performance of a contract becomes impossible after execution of a contract and it is due to an event or an effect which the party undertaking the obligation could not prevent, then such contract would become void, or as the name suggests, frustrated. So there are two kinds of situations where the doctrine of frustration would not apply. First is where the event or circumstance has been self-imposed, and second, where the contract provides for the continual performance of the obligation of parties irrespective of occurrence of certain events. So the concept of restitution under the Indian Contract Act is derived from the common law principle that seeks to prevent unjust enrichment. In other words, it means that no party to a contract should be allowed to unjustly enrich or benefit itself at the expense of the other party. Now, having understood these three concepts of force majeure, frustration, and restitution, the most important question is how all of these concepts fit into our overall discussion about the COVID-19 pandemic and performance and enforcement of contracts in that context. Now, it is being lately observed that a lot of parties to commercial contracts are approaching law firms, are approaching the courts of law and trying to understand their legal remedies or trying to understand how they can avoid performance of the contract or delay performance of the contract because of the COVID-19 pandemic, which has resulted in a near complete shutdown of their business operations, for example, or has rendered it completely impossible for that party to perform its side, its part of the reciprocal obligations. Now, in this regard, it is very important to understand what we've discussed earlier, is that the benefit or the defense of a force majeure event or an act of God event, which would obviously include the COVID-19 pandemic, would only be available to a party if that is specifically set out in the contract. Now, this is critical because what this signifies is that if the contract does not have an express force majeure provision, it means that the parties originally never intended the contract to be a conditional or contingent contract. They never envisaged that there could be any situation which is beyond the reasonable control of either of the parties, which would lead the parties to renegotiate the terms of the contract or reassess the concepts and reassess the timelines, for instance. However, frustration of contracts is not contingent on there being a specific clause in the contract, and it just applies across the board to any contract governed by the Indian Contract Act. So it is imperative for a lawyer, especially when it's advising the client on whether an act of God defense can be claimed, or whether the contract is liable to be frustrated because of a party not being able to perform its obligations as a result of the shutdown. There are various considerations that need to be kept in mind from a practical standpoint. Now, some of these considerations, for instance, would be: one, the term and nature of contract. Second would be the factual background. Third, parties' knowledge and expectations about the risk. As I just pointed out, a lack of a force majeure clause would kind of signify the parties' expectation and assessment of the risks involved in performance of the contract. And lastly, the parties' ability to perform in the current circumstances. Now, it has also been observed that a lot of parties are unjustly trying to claim a benefit out of the COVID-19 situation, where their default or where their non-performance clearly does not directly stem from the COVID-19 pandemic. And it's just that they have kind of built an excuse around the pandemic and said that, I can't perform my part of the obligations. Now, it needs to be closely monitored whether the case is particularly fit for application of the doctrine of frustration, or whether a defense of force majeure on an act of God can be claimed, or whether none of these defenses can be claimed because your actions are not attributed to the pandemic or the shutdown of business operations. So, as discussed earlier, while analyzing the threshold for claiming the defense of force majeure or frustration of contract, the threshold is not a casual difficulty or an operational inconvenience, and it is also not a complete impossibility of performance of the contract. It actually lies somewhere in the middle, and courts are generally giving a more practical and purposive interpretation to the contractual terms and the provisions of the Indian Contract Act. An interesting case in this regard was the Halliburton versus Vedanta case, where Halliburton, being an oil rig contractor, had a contract from Vedanta for construction of certain oil related infrastructure, and despite multiple delays, Halliburton was not able to perform its part of the obligations, and Vedanta sought to invoke the bank guarantees. Halliburton approached the court and claimed that they were not able to perform the contract because of the COVID-19 pandemic. Now, there were multiple orders by different benches of the Delhi High Court, and a larger bench has finally ruled in favor of Vedanta and has said that the non-performance of the contractual obligations by Halliburton had actually arisen much before the COVID-19 pandemic had its full effect and the lockdown was imposed. One other interesting observation made by the court was that Halliburton's non-performance of the contract was not caused by the COVID-19 pandemic. So, it really depends on a case-by-case basis, and it needs to be tested whether any of these defenses are going to be available in your case or not. And there's no general rule, of interpretation that can be applied to all contracts. So, in this regard, perhaps we can follow a good faith approach, which would involve the following steps. Firstly, parties should, depending on the stage of performance of the contract, if it's an early stage contract, be able to renegotiate the terms or maybe alter the performance timelines of the contract. Secondly, parties should revisit and sort of re-examine their existing force majeure clauses and see whether it kind of fits in a COVID-19 pandemic kind of a situation, to give either of the parties the defense or an excuse to extend the performance timelines or renegotiate the terms of the contract. Thirdly, each of the parties should keep the counterparty informed of all extraneous circumstances which is making it difficult or impossible for that party to perform its side of the obligations. Fourthly, parties need to do whatever is reasonable to ensure due performance of the contract. The underlying principle here being that difficulty is not impossibility. I mean, you have to, if required, take those extra 2 steps which is within your reasonable control to ensure that the performance of contract is not hindered by the pandemic. That new principles of law would emerge from the wisdoms of the courtroom, which may not conform to the conventional standards of what is right and what is wrong, the conventional practices and principles of corporate law that have already been established, but they would be more practical in nature, and perhaps the courts would definitely look at each case from the perspective of justice, equity, and good conscience, more than ever, I would say. I mean, and you ask me why? I mean, because the law and the courts would also need to adapt to the new normal, wouldn't they? With this, I would like to end the discussion. Thank you very much once again for inviting me and giving me the opportunity to speak on performance of contracts, and wish you all the best for the future. Thank you.